Hello, everyone, and welcome to today's webinar. We're in for a really interesting session today with Streamsowers Köhn, which will cover arbitration law and practice in Nigeria. My name is Nisha Sawan. I'm a deputy editor on the Chamber's Global Guide, and I am delighted to be joined by Streamsowers Köhn partner, Etigwe Uwa, Streamsowers Köhn senior associate, Vincent Owo, and Herbert Smith Freehill's head of global arbitration practice, Paula Hodges. Today's session will last 90 minutes and will largely address three main topics, starting with a look at the arbitrability of disputes in Nigeria, as well as the English law perspective, moving on to anti-arbitration injunctions in Nigeria and the approach of the UK courts, and finally looking at the enforcement of international arbitration awards in Nigeria and in the UK. If you would like to join the conversation, we're able to accept questions via the text box on your screen or by emailing events@chambers.com. Should you have any technical issues, please click the question mark button at the bottom of your screen, where you'll be able to find some helpful tips. And now we move on to today's session. And Vincent, it's over to you.
Thank you, Nisha. Good morning, everyone. Welcome to this session. We hope to have a very interactive session, so we encourage you to resolve your questions as we go on. We'll find the time to address them. And so to cut to the chase, we'll quickly delve into the concept of arbitrability in Nigeria. So the format we've chosen for this webinar is that Mr. Uwa is going to speak to the Nigerian elements of each subject matter, and Ms. Hodges is going to speak to the UK and international best practices. So that's the format we've adopted. So they're going to have, at times, contrasting positions. So we'll move ahead. The concept of arbitrability is simply that certain matters, although parties have liberty to enter into arbitration agreements and all of that, but by operation of law or certain circumstances, certain matters cannot properly be resolved by an arbitration process. To discuss the ambit of this subject matter, I would welcome Mr. Uwa to talk about the Nigerian law perspective on the concept of arbitrability. What are those elements of Nigerian law that cannot be resolved by arbitration? And I would like him to matters have come up lately, controversial subject matter, like tax disputes. So, Mr. Owa, over to you, please.
Thank you very much, Vincent. So the concept of arbitrability in Nigeria is not provided for directly in the Arbitration and Conciliation Act, but there are provisions in the Act which deal with the issue by implication. In Section 35 of the Act, there's a provision made that nothing in the Act will affect any other law by which certain forms of disputes may not be settled via arbitration, or any other law which allows arbitration only under certain conditions or in accordance with the provisions of that particular law. So in the Arbitration and Conciliation Act, there's no direct provision dealing with the issue of arbitrability. It doesn't define what arbitrability is, but it just says that if there is any other law that makes it impossible for certain kinds of disputes to be settled via arbitration, those laws will be valid. And so if you also look at Section 48 of the Act, dealing with setting aside of arbitration awards, one of the grounds upon which a court can set aside an arbitration award is if the court finds that that particular dispute is not is not one which can be resolved via arbitration according to the laws of Nigeria. So with those two provisions, although no direct provision is made about issues about arbitrability, you can actually find disputes that are not arbitrable by deduction by looking at the provisions of other laws. in the country. One provision that readily comes to mind is the provisions which you have in many of the tax legislations in the country. They don't specifically say that tax disputes are not arbitrable, but they set out the ways in which disputes relating to tax matters may be resolved under Nigerian law. And those specific ways in which you can resolve those disputes are actually set out. They include going to court, they include appeals to the tax tribunal, and so on and so forth. Arbitration is not one of those means by which you can resolve tax disputes. So on account of that, the Federal High Court and the Court of Appeal in the PSC arbitration matters, specifically the one involving ESSO and Nigerian National Petroleum Corporation, and the one involving Shell and Nigerian National Petroleum Corporation, held that tax disputes are not arbitrable. And on that basis, disputes which had been submitted to an arbitral panel and in respect of which an award had been issued, the award was actually set aside. So that's one example. In a particular case, the Kano State Urban Development Case and Funds, the Supreme Court looked at the issue and gave general guidelines as to issues which are arbitrable. And the Supreme Court took the view that matters that change the status of a party, matters in rem, such as arrest of vessels, matters like winding up of companies, matters like indictment for offenses, and things like that, are not matters which are arbitrable. So in a nutshell, under Nigerian law, there is no specific setting out or codification of the kinds of disputes that are not arbitrable. But if you look at some of the other laws, you would find certain disputes that are not arbitrable. And you will find some other laws which specify certain conditions that must be met for certain disputes to be arbitrable. So if you're going to deal with an issue in this regard, it's not enough to look at the Arbitration and Conciliation Act alone. You have to look at all the other laws that regulate all the other disputes and to determine whether, based on those laws, the particular disputes that you're talking about is arbitrable. Thank you.
Thank you, Mr. Owa. Thank you for your concise presentation. Ms. Hodges, leading from where Mr. Owa just ended, would you comment on whether tax matters are arbitrable in the UK, and also whether all commercial disputes, there are instances where we have some jurisdictions where they categorize certain commercial disputes that are not arbitrable. So even though they are clearly commercial disputes, they're not arbitrable in certain jurisdictions. Can you shed light on what the UK position is, especially with particular reference to tax disputes, and then you can go ahead to make other references to other relevant subject matter?
Well, thank you very much, Vincent and Chambers and Mr. Uwa, for inviting me here today. I'm absolutely delighted to be participating. I have to say, seeing the picture on the screen makes me realise how much I'm missing my visit to Nigeria and Lagos in particular, but hopefully that will be resolved in the near future. So arbitrability, I think, is one of the more elusive concepts in international arbitration, because as Mr. Uwa has already identified, under Nigerian law, there's no precise definition of what arbitrability is. It's a similar position under UK law, which I'll come on to. But I think the reason for that is there's no set international agreement as to what arbitrability means. For instance, if we look at the New York Convention, it makes clear that parties who have a defined legal relationship can decide to have their disputes decided by arbitration. And the only carve-out is where a dispute is not capable of being settled by arbitration, which is, of course, very broad and doesn't tell you very much. But I think the reason for that is that the convention allows individual countries to decide which types of disputes they want to exclude from arbitration. And that nearly always involves a public policy reason. So, for instance, under UK law, again, under our Arbitration Act, it makes clear that all disputes arising from contracts or other situations where there is a legal relationship between the parties can be resolved by arbitration unless it is necessary to safeguard the public interest, in which case the dispute then has to go to the court. So this is essentially a jurisdictional issue. The good news is, in the UK, that the English courts have always taken a very pro-arbitration stance. So they will not interfere in the arbitral process to any degree. And unless there is a significant public interest issue in play. So most of the time, the courts will allow the arbitral tribunal jurisdiction and whether or not the dispute should be settled by arbitration. But, of course, there are the odd exception. And the exceptions normally relate to criminal matters, family matters, real estate, and then also tax. But it depends what sort of tax dispute it is. If it is relating to a dispute with the tax authority in the UK, then that is not arbitrable. And you have to resolve your dispute before particular tax tribunals. But if the tax dispute relates to a contract where two or more parties have agreed, for instance, the allocation of tax between them and have included an arbitration agreement in the contract, well, that dispute will be arbitrable. Again, in the international context, so if it's, for instance, a dispute under investment treaty convention, it could well be that the dispute is arbitrable if the investor is complaining about the host government having changed the tax regime when there's a stabilization clause in the contract. So in an investor-state scenario, there could be even a wider scope of dispute that's subject to arbitration. I also wanted to touch on shipping disputes because certainly in the UK, the court, the Admiralty Court, does hold jurisdiction over a lot of shipping disputes relating to collisions, salvage. But on the other hand, if it relates to commodities, import or exports, insurance, reinsurance of ships, well, that's all arbitrable. So it really does depend on the type of issue in hand. I just wanted to touch on one other type of dispute under UK law, and that is if there is any issue of illegality, the English court will tread very carefully. So I'll give you an example. Up until about 15 years ago, gambling was illegal in the UK. And there was a particular case which the claimant was trying to recover its gambling winnings. And there was an arbitration agreement. And in that case, the court would not allow the issue to be decided by arbitration because it was an illegal contract. Obviously, there's new legislation now and there's regulation of gambling. So it'd be interesting to see what the English court would say today as to whether or not the dispute would be arbitrable. But certainly, if there is a question of illegality under English law, it is more likely or not that the court will then take jurisdiction over the dispute. If it is a question of invalidity of the contract, on the other hand, so there isn't an issue of illegality, the English court is more likely to allow the arbitral tribunal to decide whether or not the matter is within their jurisdiction, within the four corners of the arbitration agreement, and whether it should be determined by arbitration. I just wanted to touch very briefly on the subject of arbitrability under Russian law. We've had a lot of experience of arbitrations relating to Russian parties, sometimes subject to Russian law. And I myself was involved in one such case. For many years, there was a concern that certain corporate disputes with a Russian party or subject to Russian law were not allowed to be determined by arbitration, but it was by no means clear under Russian law. And the case that I referred to, that I was involved in, was between two Russian parties. It was subject to Russian law, took place in Moscow. My colleagues in Russia conducted the arbitration. We got a successful award, but we needed to enforce it outside of Russia. But the losing counterparty took steps to have the award set aside in Russia and succeeded in doing so, which then put us at a very difficult disadvantage in terms of enforcing the award. And the main reason for the set-aside was that this was a corporate dispute which should not have been arbitrated. But actually the dispute related to a share purchase agreement of shares rather than in relation to the articles of association of the company or a corporate dispute in the strict sense. But anyway, we tried to enforce the award in a number of different countries. We succeeded in France, which always applies its own law deciding whether or not a dispute should be arbitrated. But unfortunately, we did not succeed in either the UK or Holland. We got very close in the UK. We knocked out 2 grounds of the enforcement, but the one point we fell down on was whether or not this was a corporate dispute. And at the time, Russian law wasn't clear. There have been reforms now which have introduced more clarity, but it just goes to show that you have to look at the laws of each jurisdiction to try to understand the arbitrability of your dispute, as Mr. Uwar said at the beginning. But Vincent, I'll hand back to you now.
Thank you very much. I'm sure we'll speak more to that when we get to the questions segment. So we'll dive into the next subject matter, which is anti-arbitration injunctions. Now, there are circumstances in which, although parties have agreed to arbitrate a particular dispute, some of those parties seek the intervention of the courts, either before the arbitration process, during, or after the arbitration process. And that is what is generally regarded as anti-arbitration injunctions. Speaking to that will be Mr. Owa, who is going to examine the position of Nigerian law. There are 2 relevant cases in Nigeria that have that contain basically the legal position on the attitude of the Nigerian courts anti-arbitration injunction, the Cresta case and the Start Oil case. So Mr. I'll be speaking to that, in what the actual position is under Nigerian law. Are we amenable to granting of anti-arbitration injunctions, or are there certain conditions the courts usually take into cognizance before granting such injunctions? Or does the Arbitration Act in itself permit the grant of such injunctions? So Mr. Owa is going to speak to that in a few minutes. Mr. Owa.
Thank you very much, Vincent. So anti-arbitration injunctions in Nigeria is, a very interesting subject matter. Just before the two cases which Vincent has alluded to, we go back to the PSC disputes. The PSC disputes involved two parties who were parties to the production sharing contract. Now, because the production sharing contracts had provisions relating to how tax liabilities will be dealt with, a third party who wasn't party to the contract, wasn't part of the arbitrations, which is the tax authority, felt that the outcome of the arbitrations would affect his interests to the extent that if the government party, if the national oil company lost the arbitration, it will have impact on the amount of tax which is available to be collected by the tax authority in Nigeria. So the tax authority then filed a couple of cases against the parties to the arbitration. And in those cases, they took the view that the arbitrations would affect their interest and that they couldn't sit by and watch the arbitrations proceed, such that if there was an award that precluded NNPC from collecting the tax in the manner in which it felt it should collect, or that defined how the tax would be calculated, that it will affect the interest of the tax authority. So the tax authority filed an action seeking a declaration that the arbitration proceedings were illegal and that the matter being tax disputes could not be, wasn't arbitrable. Now, the matter was resolved by the Federal High Court, and the Federal High Court agreed with the position of the tax authorities, holding that the issues were not arbitrable, and then granted an injunction restraining the continuance of the arbitrations. However, at the time when the action was filed, the arbitrators were not made party to the action. And at the time when the action was filed, the proceedings were at a very advanced stage. Parties had actually finished the hearing, and what was left was for the arbitrators to render their award. I suspect that because the arbitrators were not made parties to the action, they took the view that they were not bound by whatever decisions the Nigerian courts had given. So they proceeded and rendered their award, and it then became the subject of an application to set aside. But coming back to the anti-arbitration point, there was then a similar PSC dispute, which was started later than the first set of PSC disputes. And the contracts were the same. The issues were basically the same because the contracts were exactly the same and they had similar issues. So with regard to this particular dispute, that was the Statoil and NNPC case, NNPC went to court and sought an anti-arbitration injunction on the basis that the Nigerian courts had already determined in relation to those other arbitrations having the same kind of contracts that the tax disputes comprised in the agreement were not arbitrable. And so an injunction to restrain the arbitration proceedings was sought by NNPC. The Court of First Instance granted the injunction, but upon appeal by Statoil to the Nigerian Court of Appeal, Nigerian Court of Appeal took the view that under Section 34 of the Nigerian relevant arbitration law in Nigeria, that courts are permitted to intervene in arbitration proceedings only to the extent provided under the Arbitration and Conciliation Act. And they looked at the entire act and formed the view that there's no provision in that act that allowed a court to intervene by preventing or by enjoining the continuance of arbitration proceedings. On that basis, the Court of Appeal set aside the injunction and allowed the arbitration to continue. I believe there is an appeal that is pending, and so I would not comment on the merits or the merits of the matter that is pending in the Supreme Court. However, in the second case, which is a Shell case against Cresta Integrated Natural Resources, a similar issue arose, and Cresta sought an injunction to restrain the continuance of the arbitration which was taking place in London. There was a thorough review of the authorities by this panel of the Court of Appeal, and this panel of the Court of Appeal came to the conclusion that because the Cresta arbitration was an international arbitration, that the provisions of Section 34 of the Arbitration and Conciliation Act did not apply to it, and it reviewed some of the English authorities on the point, which referred to certain statutes which had their parallels in Nigeria, almost with almost the same kind of wording, and came to the conclusion that the courts actually have the power and authority to injunct arbitration proceedings from going ahead. And an injunction was granted. It's important to note that in the Cresta case, the arbitral proceedings were just about starting. They hadn't gone far in the proceedings, whereas in some of the other cases which I had alluded to earlier, proceedings had gone very, very far. So the court took into consideration the fact that the proceedings were at the early stage and not much had happened. And Cresta also took the point that it was a much smaller company and that it was going to be very onerous and vexatious for it to go through the arbitration proceedings with all the attendant costs and so on and so forth, in comparison to the other party, which was a much bigger company. And on that basis, the court granted the injunction. Now, there are a few issues that arise from these cases, particularly the first one, which said that the court can only intervene as provided under the Act. But it does appear to me that there's an issue that wasn't taken in that litigation. Section 34 says that in matters under the Act, the court can only intervene as provided for under the Act. It does appear to me that if there is an issue about arbitrability, then it raises a question whether that matter is a matter under the Act. Because if you say that the matter is not arbitrable, then it means that the Act, which regulates arbitration, does not apply to it. But that point wasn't taken before the Court of Appeal. It will be interesting to see how the Supreme Court will resolve the issue. So in conclusion, there are two different cases. Clearly, on the issue of domestic arbitrations, the current position of the law is that the courts cannot enjoin arbitration proceedings from going on. With regard to international arbitration, the court can. But I make the point that ultimately the issue as to whether a court has the power to stop domestic arbitration proceedings is a matter that might be looked at again if the issues I've talked about the applicability of Section 34 of the Arbitration and Conciliation Act is argued before a relevant court. So I'll hand back to you, Vincent.
Thank you, Mr. Owen. Okay, so I'll move over to Ms. Hodges. We want you to focus on the circumstances in which the UK courts would consider granting anti-arbitration injunctions. I will also want you to contrast the UK position on anti-arbitration injunctions with the civil law position as obtainable in France. And then you might also chip in any other relevant jurisdiction to this discourse. Over to you, Ms. Hodges.
Thank you, Vincent. Well, I think it's fair to say that arbitration injunctions are quite a controversial topic in international arbitration, with a number of members of the arbitration community questioning whether national courts should have the power to decide whether or not an arbitration proceeding should commence or continue. And that controversy stems from the UNCITRAL model law. It's in Article 5, which says that courts should not intervene except where provided for in the law. Now, the English Act is not as express as the UNCITRAL model law, in that it says that the English courts should not intervene rather than they shall not, which gives the English courts some room for manoeuvre. There's a similar position taken in Hong Kong, which of course is another common law jurisdiction. This is certainly to be contrasted with civil law countries, such as France, but many others, where the principle of competence of France, so the competence of the arbitral tribunal to determine their own jurisdiction, is given the highest priority. But let's just take a closer look at the English law position. So although as I said, the Arbitration Act has given the English courts a little bit more room for manoeuvre, I think it's fair to say, because of the pro-arbitration approach of English courts, they proceed with great caution in actually issuing anti-arbitration injunctions. And indeed, recent cases have made it clear that injunctions should only be granted in exceptional circumstances. But what are those exceptional circumstances? So some examples that the court has given is, are the legal or equitable rights of one of the parties being infringed or threatened to be infringed if the arbitration continues? Or are the arbitration proceedings vexatious, oppressive, or unconscionable in some way? So to give you an example, there was a case in 2019. It was the case of Saba versus Khoury, which went to the Court of Appeal. And that involved an arbitration in Lebanon. And what was being argued there by the claimant was that not all of, and this is the claimant, or rather the applicant for the injunction, was arguing that some of the claims that were being brought in the arbitration in Lebanon were not covered by the arbitration agreement. So in that case, the English court undertook a very detailed analysis of all of the claims, and it decided that certain of the claims were within the scope of the arbitration agreement and could proceed to be determined by arbitration. But there were other claims that did not fall within the arbitration agreement. And in relation to those claims, they did allow and uphold an anti-arbitration injunction. Now, looking at the wider context, as I said, civil law jurisdictions are very likely to refuse an anti-arbitration injunction. In fact, civil law jurisdictions do not like issuing anti-suit injunctions at all, whereas, of course, you probably know the English court's quite happy to issue anti-suit injunctions, and often does actually in support of arbitration, where someone has brought litigation proceedings instead of observing the arbitration agreement. But of course, we're focusing on anti-arbitration injunctions today. But as I mentioned earlier, the Hong Kong position is similar to the UK. it's been made clear that they will only issue anti-arbitration injunctions very sparingly and adopting great caution. But an injunction was granted in the recent case of SA versus KB, where again the underlying contract, or rather the scope of the arbitration agreement and the underlying contract did not cover all the claims being brought. So I think there's a delicate balance to be struck with the courts, that parties are not overstepping the mark in including too many claims within arbitration agreements, while at the same time adopting a pro-arbitration stance in most cases. So all I would say is, in terms of strategy and how you deal with situations where you think a claimant is trying to expand the scope of the arbitration agreement, is if you are going to if your clients are going to participate in the arbitration, clear that you do not accept the jurisdiction of the arbitral tribunal, participating to object to the scope of the arbitration, and then also consider whether you need to apply for an injunction to stop or stay the arbitration while these issues are considered in more detail. And normally that would be done at the seat of the arbitration. So lots of interesting issues to take into account. But Vincent, I'll hand back to you now.
Thank you very much. We'll get back to you on some questions from the participants later on. So we'll just move on to the next subject matter, which is the enforcement of international arbitral awards. I'd like Mr. Awa to come in on this one. I'd like you to examine currently in Nigeria, the modes of enforcing arbitral awards. And then I would also like you to speak specifically to, there's a novel point now that has to do with whether or not winding up can be an appropriate means of enforcing an arbitral award. So I'd like you to address that scope for us, Mr. Awa.
Thank you very much, Vincent. Like all other countries that are signatory to the New York Convention, an arbitral award is recognized as binding. And in Nigeria, in sections 31 and 51 of the Arbitration and Conciliation Act, if you want to, you can apply to enforce an arbitration award. And the steps are fairly easy. There's no specific provision set out in the Arbitration Act, but the Supreme Court has held that the appropriate procedure to adopt is by filing an originating motion. And all you're required to do is to submit a certified copy of the award and a certified copy of the arbitration agreement. That's one way of applying for enforcement. Another way you can apply for you can try to enforce an arbitration award is to actually sue on the award and bring an action for judgment to be given in the terms of the award. Yet another way in which you can enforce an arbitration award is by going through the Foreign Judgments Reciprocal Enforcement Act, which is applicable in Nigeria. Under that act, judgments of other countries can be enforced in Nigeria if reciprocal treatment is given to Nigerian judgments in those countries. It applies to Commonwealth countries and other countries to which the Attorney General has extended the application of the Act. The important thing is that that Act defines a judgment to include an arbitration award, provided that that arbitration award leave has been granted for its enforcement and therefore has assumed the status of a judgment of the country where the arbitration award was made. So if there's been an application for enforcement and that application has been granted in a foreign country, then that arbitration award assumes the same status as a judgment of that particular foreign country, and then you can apply to register that judgment and in so doing enforce the arbitration award. The most popular means of enforcing arbitration awards in Nigeria is simply applying for leave to recognize and enforce the award, as I indicated earlier. However, one issue which most people would encounter is that as you file the application to enforce the award, most times you would have an application filed to set aside the award. The Supreme Court of Nigeria has held in the Shell and Imani case that where you have those two applications pending at the same time, an application to enforce and an application to set aside or remit the award, the proper thing to do is to take the application to set aside or remit the award first before considering the application for enforcement. It's also been held that it is possible to consolidate the hearing of both applications provided they are pending before the same court. And the court in that particular case had said that it was better if you've been served with an application, whether it's an application to enforce or an application to set aside, and the other party wants to file a counter application. So if, for instance, an application to set aside has been filed and you want to file an application to enforce, that it makes better sense to file that application in the same court so that if it were possible for the court to consolidate the hearing of both applications, that can be done. So but you would find that because of that, and because the cost regime in Nigeria is not the same as you have in the UK, where if you file an action, you will be responsible not only for your costs, but for the costs of your opponent. The cost in the regime in Nigeria is very, very lenient. And so you would hardly find any court in Nigeria awarding more than, a maximum of $1,000 as cost. And that's because of the principle that, access to courts should not be denied or should not be limited, because people would have the fear that if they went to court and they lost, they'll be punished severely in terms of cost. So because of that, you would find that most people who lose in international arbitration matters would want to buy time, or would just sometimes want to scuttle the ability of the winning party to reap the fruits of the arbitration award by filing applications to set aside. And those applications take a long time to resolve. Sometimes they are resolved in the High Court. There is an appeal to the Court of Appeal and a further appeal to the Supreme Court. And so this has a way of delaying the enforcement of arbitration awards. Thankfully, the judicial attitude in Nigeria now has changed significantly. In May 2007, the Chief Justice of Nigeria issued some kind of a directive to all heads of courts, encouraging all heads of courts to issue practice directions which would make the hearing of arbitration matters to be expedited, and especially issues relating to enforcement, so that they are not bogged down by all kinds of procedural issues. So the current attitude of the courts is to try and ensure that these matters are dealt with as expeditiously as possible. The courts have held in Nigeria that once there's an arbitration award which has been made, that it is conclusive of all the issues which were submitted to the arbitrator, and that upon an application, it should be enforced. And the only reason that it may not be enforced is if it's void or it's not arbitrable or things like that. Now, I had earlier mentioned the three means by which you could enforce arbitration awards. The one relating to foreign judgments reciprocal enforcement is something that people might want to pay some more attention to. If for any reason you delay in bringing an application to enforce an arbitration award in Nigeria, say because you've tried to enforce in other jurisdictions and you thought that you'll be successful in those jurisdictions, and by the time you're trying to enforce in Nigeria, you've had problems about limitation. If that award had been successfully enforced in another jurisdiction, then you may want to come under the foreign judgment reciprocal enforcement, because in that regard, time will begin to run, not from the time of the award, but from the time when leave to enforce the award as a judgment was granted in the court of the country where it was enforced. There might be some other technical problems with applying for enforcement under the Act, under Sections 31 and Sections 51. If you encounter those kinds of problems, you may want to consider whether you will just sue on the arbitration award and get a declaration or a judgment that the amount awarded to you via the award be paid over by the respondent. Now, there are a couple of issues which have arisen in recent times. There's a provision of the rules of the Federal High Court which allow a party who is the beneficiary of an award to apply ex parte to have the award enforced. Now, there have been arguments as to the constitutionality of that provisions of the Federal High Court rules, and certainly in matters I was involved in, that rule was applied and arbitration awards were enforced even before we knew that there was an application for enforcement, and that is actually provided for under the Federal High Court rules. That particular enforcement was challenged in those cases, and the enforcements were set aside. The case which I had referred to before, Shell and Imani, is to the effect that if you're going to have something like an enforcement which affects the rights of other parties, it's not something that you should be able to do ex parte. The other party should have an opportunity of dealing with the issue. The other party may, for instance, say, look, I have an application to set aside, and therefore you should stay proceedings in respect of the application to enforce. But if that application were to be allowed ex parte, then that party would not be able to advance whatever arguments it has against the enforcement. That party may, for instance, apply to the court to refuse enforcement on the basis of the fact that the award is contrary to public policy, or the award is with regard to a dispute that is inarbitrable. So that's one little problem that I see there. There are some other rules of certain courts in Nigeria that don't require you to file an application to enforce. All you need to do is that you can file the arbitration award in the registry of the court, and having filed it in the registry of the court, it becomes immediately enforceable. So if you have an arbitration award, it's important to look at the rules of the various courts and know what particular court or what particular rules would help you to enforce the award as expeditiously as possible. Under our Admiralty Jurisdiction Act in Nigeria, one of the grounds for which you can bring an Admiralty action in rem is if you are enforcing an arbitration award which has been issued by an arbitration tribunal. I've been involved in some cases where a party just went ex parte and arrested vessels belonging to my client, and that actually gave them a lot of leverage that induced my client to settle the matter. So instead of, first of all, applying to enforce the award, they just went straight ahead and applied to arrest the vessel, which is done ex parte. So at the time my client got wind of the matter, it already had some preemptive orders against it, which were very crippling for his business, and it was forced to settle. So these are some of the issues. Now, there's a recent decision of the Federal High Court in Abuja, where a party who is the beneficiary of an arbitration award applied to wind up the company that is the award debtor. At this particular point in time, proceedings were still pending in relation to the setting aside of the award or in relation to enforcement. The respondent to the winding up proceedings argued that to the extent that leave to enforce had not been granted, that it was premature to file winding up proceedings. We argued that the arbitration award is binding and that all that leave to enforce does is to invest that award with the coercive powers of state so that you can use the machinery the machinery available for enforcement of judgments to recover your judgment. But it does not mean that there is not a debt which is due for payment. The court agreed with us and said that there was no necessity for you to have gotten an order to enforce an arbitration award before you can use that arbitration award as a means of applying for the winding up of the award debtor. So those are some of the cases and some of the trends that we're seeing with regard to the enforcement of arbitral awards in Nigeria. Back to you, Vincent.
Thank you, Mr. Owan. So, Ms. Hodges, I'd like you to comment on the modes of enforcement in the UK and some of the challenges that parties face in trying to enforce arbitral awards in the UK.
I will do, Vincent. The UK is, of course, a signatory to the New York Convention, so it has agreed to uphold and enforce arbitral awards, subject to only a few exceptions, which I'll come on to. So the Arbitration Act in the UK provides two different routes to enforcing awards. There's a more summary procedure under Section 66. The provision that most parties use is Section 101, which deals with enforcement of awards under the New York Convention. And to be honest, there isn't a huge amount of difference between the two at the end of the day. And indeed, the High Court has made clear in a recent case for data assets that in the absence of a challenge by the award debtor, enforcement of awards in the UK is highly summary and essentially a quasi-administrative process. So overall, the English courts will take an extremely pro-enforcement stance. But what are the impediments that can be raised to challenge or prevent enforcement? Well, the key grounds are encapsulated in Article 5 of the New York Convention, which will be familiar to many of you. And they are limited for the most part, so they relate to whether the parties had capacity to enter into an arbitration agreement, whether the subject matter of the contract or dispute is arbitrable. So going back to the discussion we had earlier on arbitrability, then the other grounds relate mostly to whether or not there's been some irregularity during the course of the arbitration. So, have the arbitrators gone beyond the scope of the arbitration agreement or the arbitration procedure agreed by the parties? Another ground is whether or not all the parties have notice of the arbitration and any hearing dates. But there's also a sort of catch-all provision relating to public policy. And that's provision that is much more vague than the other grounds of the New York Convention. That said, the English courts have made very clear that they will only use the public policy ground to prevent enforcement in very limited circumstances, and have said that judges should proceed with extreme caution if they're going to apply the public policy route. Now, there's an interesting case going through the English court at the moment. It's called Kababji versus Kauk Food Group. It involves a Lebanese party and a Kuwaiti party. It's a Paris-seated arbitration. And you may have seen in previous cases, there's sometimes a bit of a tussle between the English courts and the French courts in relation to enforcement. The French courts nearly always uphold arbitral awards, whereas the English court will check that the grounds for resisting enforcement set out in the New York Convention have been applied. So in this case involving Kababji and Kauk Food, the English High Court has held that KFG, so Kauk Food Group, was not a party to the arbitration agreement, so has said that the award should not be enforced. But it's making its way up to the Supreme Court, because this is a Paris arbitration, to make sure that the English court has reached the right conclusion. So we're watching to see what happens in that case. To give you an example of an unmeritorious attempt to challenge enforcement of an award, though, there was a recent case involving Shell again, and a group called Meta Energia. And in that case, Meta tried to argue that the award should not be upheld because they had been unable to retain a leading advocate to represent them. I'm afraid they got short shrift from the English court, who said that fell far below the bar that was required to stop the enforcement proceeding. And indeed, the English court held that the arbitral tribunal had been scrupulously even-handed in how they treated the parties during the arbitration, and that the process had been unimpeachably fair. So it really is a high bar that you have to jump in order to stop enforcement. Another ground is that the award has been set aside at the seat. So going back to the example I gave you earlier in Russia, where the arbitration award was set aside because the Russian courts held that the dispute was a corporate dispute that was not arbitrable. So again, the English court will look very carefully at whether or not the award has been set aside at the seat of the arbitration and whether that was a valid decision to take. And in a recent case of 2019, which has a Nigerian aspect, it was a party called AIC versus the Federal Airport Authority of Nigeria. The court made clear that in deciding whether to grant a stay of enforcement of an award, they should take into account whether the challenge to the award had been brought in good faith, whether there was a realistic prospect of success, and whether enforcement would be rendered more difficult if there was a delay in enforcement. Now, of course, these are quite nebulous concepts, including good faith and a realistic prospect of success. But the English court said that they will only undertake a brief consideration of the merits of the challenge. And I think the underlying theme that came out of the judgment was that the court will only stop enforcement if they think that there is no realistic prospect of the award being validly upheld, or looking at it the other way, whether if the challenge is manifestly unlikely to succeed, then of course they will proceed with enforcement. Of course, even if a stay of arbitration is granted, stay of enforcement is granted while the issues are being considered, that stay can be lifted. And that, of course, happened in another case involving Nigeria, and that was the IPCO versus NNPC case, where there was a sufficient change in circumstances, sufficient evidence was brought to the court, and in that case, the stay on enforcement was lifted. I just wanted to quickly mention another option that's available, and that is a party who's been successful in an arbitration can seek to try and enforce it in the UK by issuing a winding up petition against the party that has not observed the award. Obviously, that requires the party to be incorporated in the UK. But it is another option to think about. You issue a statutory demand, but then, of course, you just stand in line with the other unsecured creditors unless you have some form of security. So, Vincent, on that note, I'll hand back over to you.
Thank you. Thank you very much for your comments. So we'll delve into the question and answer session. There have been quite a lot of questions that have come up in the course of your presentations, and so I'll just I'll start with Mr. Owa. So, Mr. Owa, this comment is on arbitrability. So the question is as to whether, given the decision of the court of the High Court or the Court of Appeal on the status of being inarbitrable, wherein reference was made to Section 251 of the Constitution as a justification for that pronouncement. All other items stated under Section 251 of the Constitution would therefore be held to based on the same footing as tax disputes. That means that the other items contained under Section 251 of the Constitution also inarbitrable. Are they going to suffer the same fate as tax disputes? Is that the interpretation? Is that the correct interpretation of the decision of the court? That's the first question for you, Mr. Owa. I think you can go ahead and comment on it, and then the next question will go to Ms. Hodges.
Okay, thank you very much. The decision that you referred to about Section 251 being the basis for deciding that tax disputes are inarbitrable, that I believe is the decision that was reached by the Federal High Court. On appeal to the Court of Appeal, and there are many of these matters because they were all similar arbitrations arising from the production sharing contracts. There are quite a lot of them that have gone through the Federal High Court and have gone on to the Court of Appeal. The most recent decision of the Court of Appeal held that Section 251 of the Constitution is not the appropriate basis for determining that a particular dispute is inarbitrable. The Court of Appeal went on to hold that Section 3G of the relevant tax legislation which provides that any claim, objection, dispute, whatever it is that you want to ventilate regarding a matter arising out of that tax legislation must be ventilated in the manner set out in that relevant tax legislation. And the Court of Appeal held that that was the basis for coming to the conclusion that tax disputes in that particular case are inarbitrable. So to answer your question, the current jurisprudence on the point is that Section 251, which is basically an allocation of the jurisdiction between the Federal High Court and the State High Court or the National Industrial Court, is not relevant in determining whether a dispute is arbitrable or is not arbitrable. There are a lot of matters set out in Section 251, including maritime matters, including matters relating to trademarks, and other matters which we all know are arbitrable and have been subject to many arbitrations in the past. So that particular decision has been limited by the Court of Appeal, and the basis for the inarbitrability of tax disputes is a provision in the relevant tax legislations that bar any dispute resolution mechanism aside from those set out in that tax legislation. Thank you very much.
Thank you, Mr. Owa. Would also, there's a follow-up question to that, so I'll just read it out to you. So this is Nigeria. It's a Nigerian law consideration, so you can as well just comment on it at once. So the question is, can an out-of-court settlement be considered as a form of arbitration? If so, can an out-of-court settlement in respect of subject matters which are non-arbitrable be voided on grounds of jurisdiction? I don't know if you got the question.
Yes, I did. I believe that specific question was addressed by the Supreme Court. I believe it's in the Raspal Ghazi case, if my recollection is correct. And the Supreme Court in that case decided that terms of settlement or a settlement issue is different from an award, and it's not that they're totally different and different considerations apply. So if you have a dispute which you have resolved and you file terms of settlement, that dispute has been compromised. You may decide in those terms of settlement to embed an arbitration clause in it, so that if a dispute arises out of that terms of settlement, that dispute can be arbitrable. But they are two different things, and there's a specific decision of the Supreme Court on the point that terms of settlement and arbitration awards are two different matters and different considerations apply. Thank you.
Thank you. We'll move to Ms. Hodges. So we have two in one. There are two questions, but we'll take them together. The first one is, what is a tax dispute? The second one is it advisable for an arbitral tribunal to proceed with an arbitration during the pendency of an application for, I'll take that one later. The second question is, following the first question on tax disputes, on what a tax dispute is whether, is it the nature of the dispute or the scope of the jurisdiction of the regular court over the subject matter that determines arbitrability? So the question, let me take the questions again so you can understand them. The first question is, the person is trying to find out what a tax dispute means, because we've used it severally in our presentations. So what does it mean? How do you define a tax dispute? And then the second question is, what determines the arbitrability Is it the nature of the dispute or the scope of the jurisdiction of the regular courts? I don't know if you got that clearly.
Yeah, no, that's fine, Vincent, and thank you for the explanation. Okay. So let's deal with tax disputes first. And as I said earlier, it very much depends what type of tax dispute it is. So, for instance, a tax dispute is obviously any dispute relating to tax. But if it's a company that is objecting to the amount of corporate tax it is being charged by the national tax authorities, for instance, then that will not be arbitrable. Then you have to follow the dispute procedures in the particular country, whether that's Nigeria or the UK. And normally there are specialist tax tribunals that deal with these issues, because they're very much within the sovereignty of the state. And so parties cannot opt out of the national procedure for dealing with them. On the other hand, if there is a contract between private entities, so corporates, for instance, it could be a operating agreement in relation to the offshore oil sector in Nigeria, and the companies may agree that they are going to split the cost of the tax that's due to the authorities in Nigeria in a particular way, perhaps according to the percentage interest they hold in the oil field. And there's an arbitration agreement in the contract. And if the dispute is just about who pays what within the joint venture, that is arbitrable. If, on the other hand, the partners have an argument with the tax authority in Nigeria about how much tax is due, then that would be subject to the national procedures in Nigeria and not arbitrable under the commercial contract. In terms of whether it's the nature of the dispute or the scope of jurisdiction of the national courts, it's actually a consideration of both of those issues, because, as I said earlier, each country will identify certain subject matter which they do not permit to be determined by arbitration. So, for instance, it's obvious when it involves crime or family law. Again, if in relation to tax, if it's a question of how much the tax authorities are allowed to charge, that will not be arbitrable, and that will be subject to the specialist jurisdiction of the Nigerian regulatory authorities, or will come within the purvey of the Nigerian courts. Again, if it's a criminal matter, it would go to the criminal courts in Nigeria or any other country. So it's a matter of looking both at the nature of the dispute and then the legislation within a particular country as to whether or not they've said, well, if it relates to tax crime, then you must go to the courts. So it's a mixture of both.
Okay, thank you. Thank you, Ms. Hodges. We'll stay with you. We have one other question for you. So it's on, we are moving straight to anti-arbitration injunctions now. And the question is it advisable for an arbitral tribunal to proceed with an arbitration during the pendency of an application for anti-arbitration injunction? What's the UK position on this? So when somebody approaches the court because of arbitration proceedings, and what should the tribunal do? What is advisable under English law? Should the tribunal continue with the proceedings, or is it mandated to halt pending whatever the determination that is brought before the courts of law is made? What is the UK position on that point?
So this will really come down to the jurisdiction of the tribunal if the arbitration is up and running. And until an injunction is in place, certainly there's no reason why the tribunal should not continue. The difficulty arises when an injunction is granted, but then there is an appeal, perhaps going to Court of Appeal up to Supreme Court, and what happens then? And I've seen tribunals take a different stance on this. And it really depends on whether or not the issues in dispute will be made more difficult if the tribunal doesn't press ahead. So, for instance, if there's a time factor that the dispute has to be decided within a certain amount of time in order to ensure that the purpose of the arbitration is still possible. So let me give you an example, because that was quite a vague point that I made. So I've been involved in a number of cases involving Nigeria, and particularly in the oil industry. And there was one arbitration which related to the split of interest in an oil field, or rather one block between two different fields. And there were different companies in the two fields. And it was all about how much oil was owed to one field as opposed to the other. And there were various injunction proceedings taken in Nigeria, and it was appealed all the way through. And one argument that was made to the tribunal for them to proceed was that if they didn't, there was a risk that the oil would not be recoverable because of various technical issues. And in that case, the tribunal decided to keep going with the arbitration in the hope that the Nigerian courts would render a decision before they had to issue an award. And I am pleased to say the Nigerian courts did move quickly, and they resolved that no injunction should be granted before the award was given. So, and then in other cases, the tribunals just decided that that there is, no risk, and they have, stayed the arbitration until the injunction issue is sorted. So I think it depends on the urgency of the relief that's being sought in the arbitration. Thanks, Vincent.
Thank you. So my question is directed to Mr. Owen. Question is, what happens where an award covers issues which are arbitrable and other issues which are not arbitrable? How are those dealt with?
Okay, thank you so very much. Just before I answer that, could I just make some little comment about the last question? And in addition to the comments made by Paula, an injunction operates in personam in Nigeria. So if it's an international arbitration and the arbitrators are not in Nigeria, the seat of the arbitration is not Nigeria, then there might be difficulty in enforcing that kind of an anti-arbitration injunction. Again, if the arbitrators are not made parties to the case where the injunction is sought, it's arguable that you cannot hold somebody who is not party to a case bound by an order of injunction. The difficulty may arise if one of the parties is a Nigerian company or is a Nigerian resident. And so if such an injunction were issued and that particular party continued with the arbitration proceedings, then there might be issues about committal proceedings or proceedings for contempt of court being issued against that particular party, which is within jurisdiction, because in that regard, to the extent that that person is within jurisdiction, the jurisdiction of the court in personam can reach that person who is within the jurisdiction. Now, to the question which you have, the other question that you've asked.
Can I take it again?
Sorry, yes, can you take that question again? Just a second.
Okay. What happens where an award covers issues which are arbitrable and others which are not?
Okay, so that is an issue which in Nigeria has been dealt with. It was dealt with by the Court of Appeal in the SO against NNPC case. Again, that was a case in relation to the PSC arbitration. So I'll just talk about what the Court of Appeal decided, because I know that there are pending appeals on the matter. So I'm careful not to stray into the merits too much. But so I'll just say what the Court of Appeal did. In that particular case, the Court of Appeal found that some parts of the dispute were arbitrable, and there were some other parts which were not arbitrable. So what the court did was to set aside the part of the award which it considered inarbitrable, and it affirmed the part of the award which it considered to be arbitrable. So that's what happened in that particular case. Whether that will be upheld by the Supreme Court is a matter that would wait to see how the Supreme Court deals with the issue.
Okay, we'll stay with you, Mr. Owa. Just one last question. So the question is, how best can Nigerian courts balance the interests of a successful party in an arbitration who desires timely enforcement of the right of the unsuccessful party to set aside the award, in light of the fact that many applications set aside are merely initiated to frustrate the award?
Well,
you get that?
I think, yes, I did.
Okay.
I did. I think that the direction which was issued by the Chief Justice of Nigeria to heads of courts, urging them to issue practice directions which will ensure that matters in relation to arbitration are given an expeditious hearing, is a step in the right direction, and I think it'd be very, very helpful. I also think that some practice directions should be issued such that if there is an application to enforce an award, any other party to the losing party should be bound, if it has an application set aside, to file that application before the same court, so that the hearing of both the application to enforce and the application to set aside can be consolidated, and you can have one set of arguments, and you can have one decision one way or the other. Obviously, if the court sets aside the award, then enforcement becomes irrelevant. If the court does not set aside the award, then it's most likely going to enforce the award, except if there are public policy issues that are involved. So I think that both applications should not be allowed to run independently. I think that it's one way in which matters can be speeded up is if they are consolidated. And I think a practice direction should also be issued that with regard to such applications, both applications set aside and applications to enforce should be considered and determined within a specific period, maybe not later than 6 months from the time when both applications are filed. That's a way in which I think there can be some balancing. I also think that a lot of people get away with dilatory actions that they take just to delay because they don't get punished if they file very, very frivolous applications set aside. I think that the cost regime should be reformed so that if you file an application to set aside and the courts consider that application to be very frivolous, you should be punished and you should have to bear the cost of the other party. So if you know that if you filed a frivolous application, you will be punished in cost, then I think that will, to some extent, dissuade people from filing frivolous applications. Thank you.
Thank you. Thank you so much, Mr. Awa. Thank you, Ms. Hodges. We have quite a lot of questions here, but unfortunately, we can't deal with everything. But we, on behalf of the organizers, we have an ebook which is going to be circulated to all the attendees, and that would make attempts to answer all your questions. All your questions are here, and make attempts to answer them. In the absence of any other, I'll hand over to Nisha to go on with the session. Nisha, over to you.
Thanks very much, Vincent. And that's all we have time for today. Many thanks to Streamsowers Köhn for today's insights, and to you, our audience, for logging on today and submitting your questions. As Vincent mentions, we have had a lot of questions today that we haven't been able to get around to. But should you have any follow-up questions that you didn't get the opportunity to ask, do get in touch with the firm directly using the contact box on your screen. Otherwise, have a great rest of the day, and I hope to speak with you again soon. Thanks so much again for joining us, and goodbye.